Good afternoon, everyone, and thank you so much for joining our webinar today, Untangling Your Enrollment Notice Requirement. My name is Amanda, and I'll be your moderator today. ERISA attorney Larry Grugin is our presenter. We have a lot of information to cover today, and I know that there's a lot of information to take in, so don't worry if you miss anything. We will, of course, be sending everybody a link to the slides and to re-listen to this entire presentation after our webinar concludes. I'm going to keep everybody muted just to make sure that we don't get any background noise, but Larry's going to pause periodically for questions. If you just hit the raise hand button, I can unmute you so you can ask your questions. If you prefer typing, you can ask the question below and I'll read it aloud for you. You can just type it in the questions box. Our next webinar will be covering HRAs, and it's on January 10th, again at 1 p.m. Central Standard Time. We hope to see you there. For now, I'm going to turn the presentation over to Larry.
Thank you very much. And what's important about that seminar on January 10th, I'll be covering the new Qualified Small Employer HRA in more detail. I'm hoping there's going to be IRS guidance that between now and then is going to be released. So I'll make sure I cover that in detail. So that's a new HRA that was part of the new bill, the 21st Century's Cures Act, that is effective 1/1, and all of us are waiting for more guidance. They haven't released that much on it. As Amanda said, this is a pretty detailed presentation today, and only because there's going to be 99 slides. Now don't panic. It's not filled with a lot of material, but I want to go through and I just want to make sure that I cover all the notices. Now, what's important here is that what I've decided to do with this seminar is I've decided to gather together all the material for any notices that you have to give employees. And this is notices at open enrollment, initial enrollment, various different events, COBRA, HIPAA. Anytime there's a notice requirement that you as an employer have to do, I'm going to be covering this in this seminar. Now, what I'm going to be doing in this seminar, I'm going to divide up the presentation into those have to be given at open enrollment or annual enrollment. Those have to be given at various events. So all of it's going to be structured. And I'm going to be discussing what the notice requirement is, who do you have to give it to, who has to give the notice out, who's responsible. So you'll have a detailed plan of exactly what the notices are, what they do, when you have to give it. And then what I'm thinking about doing is coming up with a packet of forms that you can have that will cover all these. Because in doing this preparation, what was interesting, as I researched various probably 15 or 20 websites, and just to get a gathering of all the forms, and not one had all these forms, which is pretty interesting. So let's go through them. So what I'm going to be doing first is recommended and mandated participant notices for all plans. This is at open enrollment and annually, and at initial enrollment. Then required notices, all plans, but not required annually or at open enrollment. And then recommended and mandated participant notices, plans that meet certain requirements. So under certain events, for example, if you're subject to COBRA, you have to give certain notices. And then mandated plans that meet specific criteria. So let's go through each one. And I have it divided up, first of all, in recommended and mandated notices, all plans. Now the first form I'm going to be doing is the Uniform Summary of Benefits and Coverage, the SPC, and glossary of forms. Now this has to be given out. What it is, it summarizes covered benefits. There's an 8-page explanation that you have to follow. It explains what benefits you're providing. Covered benefits provides examples of how plans and benefits in specified circumstances. This also includes a glossary of common health plan terms. Now, what confuses a lot of people is that this is in addition to the requirements of the SPD and SMM requirements. And this only, it says all plans, it includes all medical plans are subject to this. So this is a blown up basically highlights brochure that you used to give out to your employees, but you have to meet certain requirements. Now, who has to provide it? Well, the plan sponsor or carrier provides to all participants and eligible employees. Most carriers are preparing SPCs, but required plan sponsors to actually provide them to participants. So if you're insured, the insurer will provide it, but they won't provide it to the employees. You have to do so. Now, what's important is that if you are self-insured, either the TPA or the employer must prepare the SPC. Now, what's also very important, certain plans are exempt. For example, FSAs are exempt, HSAs are exempt, and also HRAs are not exempt. And basically what I do is I have a model HRA form that a template that I give out, which is much less detailed than the 8-page form that is provided by the government. And basically it summarizes the terms of the HRA. And I would recommend using something like that than you having to use the 8-page explanation that the government provides. Delivered. When does this form have to be given out? Well, with open enrollment materials and also at initial enrollment. And what's interesting is at open enrollment, what you have to provide is at initial enrollment, you have to provide the SPCs of each plan that you offer. At open enrollment each year, you only have to give out the SPC for the plan that they were in last year. So you don't have to give out all of them. It has to be given out also within 7 days after requested, and with 90 days after a HIPAA special enrollment, if automatic enrollment, at least 30 days before the first plan year. So here it's important, and then there's a special rule if the insurance company doesn't provide it immediately. You have 7 days after they provide it to you if you can't meet that 30-day requirement. Next, how is it provided? You can either do it on paper or electronically, and under a frequently asked questions guidance provides a relief relating to distribution requirements by noting that unless the plan or insurer has knowledge of separate address, you can provide that SPC to the one per family, and that's what that statement is trying to say. Now also there's a penalty for not providing. A penalty of $1,000 per failure if you don't give out a SPC, and it's a failure with respect to each participant or beneficiary constitutes a separate offense. And the fine cannot be paid from the plan or trust assets. It's going to be something that the employer has to pay. So make sure that you give out an SPC to each participant, and especially, and this is going to be interesting, if you have family members that live separately, especially adult children, and you know they live at a separate address, you have to give them a separate SPC. Updating. If there is a, during the plan, and what this slide 11 is trying to say, is that if during the year you make a change that affects the terms of the SPC, there's a plan change during the year. And one thing to note here is the fact that you have to give participants at least a 6 days advance notice. So this requirement, that 6-day advance notice requirement, only applies if the change is in the middle of the year. And it's only if it's a material modification. You're changing deductibles, co-pays, co-insurance, you make changes to your plan at the beginning of the year, and where this is really interesting is when you have a termination of the plan. Of course, that changes the information in the SPC. So, so that 6-day requirement only if the change is mid-year. The next form is Women's Health and Cancer Rights. In this situation, what this basically indicates, and there's sample language on this, It must state that the individual who is receiving benefits under the plan in connection with the mastectomy or elects breast reconstruction will be provided in a manner determined in consultation with the attending physician in all stages of reconstruction, surgery, prosthetics, treatment of physical complications. This applies to all medical plans, and the notice must also describe any deductibles or coinsurance limitations applicable to such coverage. This has to be given out by the plan administrator. It can't be delegated to the carrier. You have to send it to all plan participants. And the DOL has interpreted this as requiring a separate notice to a beneficiary where last known address of the beneficiary is different than the last known address of the covered participant. So again, if you have adult children that are living separately, then it must be provided separately. Now, the next thing is that when it has to be given, it has to be given out annually or and upon initial enrollment, usually sent at open enrollment. And the DOL has provided that notices must be delivered in the same manner as the DOL regulations and SPDs, which means it can be provided either on paper, hand-delivered if you get evidence of that, or electronically. Another form is the HIPAA Notice of Special Enrollment Rights. This is an extremely important notice because basically it informs the employee if they decide to waive coverage when they can come in and enroll at a time other than open enrollment. Generally, this is given out at initial enrollment. Special enrollment is available. Loss of cover, eligibility for group coverage. Somebody waives your coverage and goes to the spouse's plan. Becoming eligible for state premium assistance. Or another one is acquisition of a new spouse or dependent. And what this notice does, it tells them, and this is an extremely important notice, because basically what it does, it informs the employee that if they have a child, for example, they can add the child during the year. And what's important is that employees have to understand that if they do have a child, they have a 30-day window to come in and register that child or enroll that child. When I was in corporate benefits, this is the biggest issue and problem that employees have, because let's say they have one child and they have a second child. Well, they think, well, isn't this automatic? You know I had a child, but you have to go in and physically enroll that child within 30 days. And if you don't come in within that 30-day period, then that child loses out and you can't add that child. So this notice is extremely important. So it's got to be provided by the plan sponsor, plan administrator, plan sponsor. It can be delegated to the carrier, and you send it or give it to the eligible employees. It has to be given out at initial enrollment, and also it must be at in the SPD. So again, and this is an issue with many employers, especially if they have an insured plan. Are you giving out an SPD? Are you giving out the contract that has that language in there? The DL has provided that notices must be delivered in the same manner as the SPD. It could be on paper or electronically. Another notice is Medicare Part D credible or non-credible notice. And basically what this does, it applies to all medical plans, and really this only applies for any employees that are eligible for Medicare. Because what this does, it informs them, okay, our coverage is credible, so therefore you don't have to go out and get your own coverage. You're covered until you physically leave our plan and go into Medicare only. So there's a credible notice and a non-credible notice that you're and again, it's for the employees to understand, is your coverage good enough so I don't have to get my own coverage? So, and this slide is very important about who you provide it to. It's only required to send to all Medicare eligible participants, including COBRA participants or eligible dependents. But it's recommended that you send it each year to all participants because you may not know whether a beneficiary or whether a dependent is eligible for Medicare. They could be eligible for disability. So as a safeguard, it's recommended that you give it to all participants, but really technically only applies to those individuals that are eligible for Medicare. Now, under the regulations, there are times that you have to give this out, and each year you have to give it out by October 15th. Also have to give it out prior to the individual's initial enrollment, prior to the effective date coverage for any Part D eligible individual that enrolls in the employer's prescription drug program. Whenever the employer no longer offers prescription drug or changes it so it's either credible or non-credible, or upon the request of Part D. But I think what's important is it has to be included in open enrollment material before October 15th of each year. And it can be delivered by paper or electronic means. And there's, again, and just know there are sample notices that and you have to check and see whether you're giving out the most recent notice. Another notice is the CHIP notice. This has to be given out annually. This is for telling people whether they're eligible, informs them they could be possible eligible for state finance assistance for health care coverage. It only applies to all medical plans, but if participants reside in a state where CHIP financial assistance is available, and on the form itself it indicates which states it applies to, and in the past Illinois was not included in that. So this has to be given out by the plan sponsor, sent to all eligible employees in states listed on the CHIP form, so you have to check the form and especially and see which states that it applies to. So it can change from year to year. It no longer includes California. So when it has to be delivered annually before the beginning of the plan year. It's recommended to be given out, included in open enrollment material. Also, it has to be given out at initial eligibility, and there's a penalty of $100 per day against the employer for not providing this form. Another form is the Newborn and Mother's Health Protection Act, and this is basically indicating for births how long the plan will cover you, either depending on what delivery you have. So vaginal delivery is less than 48 hours, cesarean is 96 hours. A group plan may also not require a physician or other health provider to obtain authorization from the plan prescribing a minimum hospital stay for the mother and the newborn, and applies to all medical plans. Now this must be included in the SPD, and again you have to make sure you give that explanation to the employee, often sent by the plan administrator or carrier, and it's sent to all plan participants. And it should be also sent, this notice should be sent with the open enrollment material. So it should be included in the SPD, but also sent with the open enrollment material. All right, Amanda, let's stop right here. This is a break for the session, for a section. Why don't we see if anybody has any questions?
Sure. So we do have one typed, which is when some of these notices are within the certificate of coverage, does a separate notice need to be delivered by the plan sponsor?
No, if you give out the certificate. But again, it all depends how often you give that certificate. If you give it out once a year, then again, you don't have to do it. But as it noted, and if you look at each notice, when it has to be given out, it has to be given out once a year. So you give out a certificate 1 year and don't give it out the second year, make sure you give out a certificate every year if it's required to do so.
Okay, we got another one, which is SBCs for an HRA. Do these have to be integrated into one document with the plan SBC?
No. I would recommend not. I've created a 2 or 3 page summary, and if you want a copy of it, send me an email. My email address is at the end of the presentation. The reason why I didn't integrate it, because it's extremely confusing. I've tried it a couple years and it just didn't work. So what I've done basically is created a SPC appendix that basically explains what the benefit is under the HRA in more layman's terms, because one thing that's very confusing, the SPC, if you look at it, it's very hard for the average individual to really understand it. It's real complicated. And what I try to do with the SPC is explain the HRA in simpler form and explain the basic design of the HRA so the average participant can understand it.
Okay. And then if we post these notices on our employee portal site, does this count as electronic notice given out, or do they have to electronically sign off?
No, but you have to give them a paper notice indicating that it's on your website. So you have to notify the employees it's there. And also you have to be careful if you have any employees that don't have an access at work with a computer, then you have to give them a paper notice.
Okay. So if you have any other questions, you can type them in the question box below or press the little raise hand button so I can unmute you to ask your question.
Anybody else have any questions?
All right, we don't have anything else on my end.
Okay, let's continue. The next category is required notices, all plans, and these are all medical plans, but not required annually or at open enrollment. And the first one is the HIPAA privacy notice. Now, there's 2 types of HIPAA privacy notices that either the carriers prepares or you as an employer prepares, and you would make sure you do it if you're self-insured. So please, and also if you have other plans, many times you want to do a HIPAA privacy. And what this HIPAA privacy notice does, it tells the plan participants about their HIPAA privacy rights, the plan's privacy obligations, and the contact information for the privacy officer if the participant wants to file a complaint. Now, as an employer, if you don't touch PHI, protected health information, you just make sure that the carrier, if they have a privacy notice, that you make sure the privacy notice is distributed to the employees, because it tells them what the insurance company is doing. For insured plans, carriers must send to all plan participants if the employer does not receive a protected health information. But if you do receive protected health information, PHI, then you have to prepare your own privacy notice in addition to the insurance company telling your employees what you're doing with their health information. So when does this privacy notice have to be given out? It has to be given out at initial enrollment. If any relevant information changes, for example, if the privacy offer changes, upon request, and then every 3 years you must notify the employees of the right to request a new notice. So again, it doesn't have to be given out every year. And then every 3 years you give just a notice that if they want another copy, they can get it. Another notice has to be given out. It's called the exchange notice. This was first given out, I think, in 2014. It tells the employees about the health insurance exchange marketplace, that the employees might be eligible for federal subsidies, info about the employer coverage if available. So it tells them what type of coverage you offer. And generally, when it doesn't have to be given out every year. It applies to all medical plans. Now, employers provide notice to all employees, full-time, part-time, whether they're eligible for coverage or not, and it tells them whether they're eligible for coverage or not. You use the model notices that are provide the DOL, and you have to be very careful because they change them and so you have to look at the bottom of the form, and it tells you when it expires. You have to go online to get a new form because they fiddle with the forms every so often and change words here and there. So you just have to make sure the form you're using and look at the effective date on the bottom to see when it expires, and it will let you know that. But again, it tells the employees whether they're eligible for the plan, whether their plan is minimum essential coverage providing minimum value. So it notifies them whether they can go on the exchange to get a credit and subsidy. So it has to be given out 14 days from the date of hire. Must give it to all employees. You can include it in open enrollment materials when the employee terminates too, to tell them what coverage they had. Now, another important form is the COBRA initial or general notice. This is extremely important because this form is important because this is a general review of COBRA. It's given out at the same time as your SPD is given out within 90 days. And the importance of it is the fact what it tells them is that what their responsibilities are under COBRA. It tells them if they have a qualifying event, if they get married, if they get divorced, if they have then they have a responsibility to tell you, and these are the procedures that you have to follow in order to tell us whether you had a qualifying event that affects your eligibility. So the DOL does provide a model notice, but I just want to warn you, it's really tough to understand. It's very complicated. It's applicable to all plans that are subject to COBRA. And again, the initial notice must be furnished by the plan administrator to covered employees and spouses when coverage first begins, and again, is within 90 days. And that's indicated here. So again, make sure that your employees get this notice, and again, it tells them what your procedures are if they have a qualifying event. And one of the biggest issues, employees don't you think employees will understand this. An employee gets divorced. It's their responsibility to tell you of their divorce. And they have to tell you within 60 days of the effective date of the divorce, because if they don't tell you within 60 days and you later find out, basically what happens is the spouse is then, you as an employer don't have to give the spouse COBRA if you blow the 60 days. So as long as you give the initial notice, tell the employees what their responsibilities are, tell them they have to notify you within 60 days. If they don't do it, then you as an employer excuse me, don't have the requirement to give that spouse any type of COBRA. Another COBRA notice is the election notice, and this is given out again when there's a qualifying event and somebody loses coverage. You have to give them election notice, and it tells them how and what COBRA they're eligible for. You know, what coverages are effective, when it's effective, what the premiums are, you know, and this is, as the name implies, this is where you elect COBRA. So election notice gives qualified beneficiaries information regarding their rights and obligations with reference to a specified qualifying event. And again, the DOL does provide a model election notice, but again, look at that very carefully because it's hard to understand, and it's applicable to all plans that are subject to COBRA. Now, when a qualifying event occurs, after the notice event is provided, the plan administrator must furnish an election notice to each, now again, to each qualified beneficiary. Now, if they're living in one place, you just give one, but if they're living, if you have a qualifying event, the family loses coverage, and you have 2 or 3 adult children that are living separately, then you have to give each one a separate notice because they have separate election rights. The plan administrator must give the COBRA notice to any qualified beneficiary with respect to a qualifying event within 14 days after the plan administrator has been notified of by the employer or the qualified beneficiary that the qualifying event occurs. And generally, if the employer is both the plan administrator and the employer, there's 30 days tacked on to that. Now, another notice is a notice of termination of COBRA coverage. And this is given out any time that a COBRA coverage ends early. So you don't have to give it out at the end of the 18 months or after the 36 months, but only this notice of termination is required when COBRA coverage ends because of the COBRA notices are not paid on time, cease to provide any group coverage, the qualified beneficiary becomes covered by another group health plan, the qualified beneficiary becomes entitled to Medicare, a disabled qualifying beneficiary disability caused by an extension of COBRA is determined not to be disabled, or it's terminated because of cause. And this, again, is applicable to all plans subject to COBRA. So the plan administrator must provide the notice of the termination to each qualifying beneficiary. And the important word is each, whose COBRA coverage terminates before the maximum coverage period ends. And if they're living at the same address, you give one notice, but if they're living at different addresses, then you have to give each one a separate notice. And this notice must be furnished by the plan administrator as soon as practicable following the decision to terminate coverage. This notice is not required to be furnished in advance of termination of COBRA coverage, so it has to be not in advance, but when you're terminating it. And again, separate notices are required when the qualified beneficiaries live at different addresses. And then another notice you may never heard of is the unavailability of COBRA coverage. This notice is anytime anybody applies for COBRA and they're not eligible for COBRA. And you must explain why COBRA coverage or an extension of COBRA coverage is not available. Somebody, for example, thinks they were covered by a plan, they weren't. They were not covered at the time of the qualifying event. And so you have to tell them, I'm sorry, but we're not going to offer you coverage. So it must be provided by the plan administrator. Notice of unavailability is required if the plan sponsor receives one of the following notices: a notice of qualifying has occurred, a notice a second qualifying event occurred, or the notice of the individual has determined by the Social Security and determines the individual in question is not entitled to COBRA coverage. For one reason or another, that person, again, and the major issue is a family member drops somebody, doesn't tell them, and they think, oh, I have COBRA because I was covered. And the administrator must furnish a notice of unavailability within a time frame that would apply for providing the election notice, which is in 14 days after you've been notified of the qualifying event. Another notice is the employer has to do is a qualifying event to the plan administrator. If the plan administrator is different than the employer, the plan administrator must be notified when the qualifying event occurs. The employer is then has to notify the plan administrator, the employer does, that there's been a qualifying event. In general, the employer must notify when there's a death of an employee, termination, or reason of gross misconduct, qualified beneficiary becoming entitled to Medicare, or the commencement of bankruptcy. And this notice must be given within 30 days after the date of the events that you just saw. All right. Amanda, do we have any other questions?
We do. We have quite a few. The first one is, COBRA TPAs generally do not send Medicare Part D notices. The plan sponsor usually doesn't send anything except open enrollment to COBRA recipients. How can we make sure TPAs understand the importance of keeping up with COBRA notices?
I think it has to be in the contract. You have to make sure that's part, and that's part of the problem. You have to look at your contracts to see who has responsibility to do what, and make sure that it's built into any administrative contracts that what notices are going to be provided to employees. Because if it's not in writing, then the TPA assumes the employer is doing that. So you have to review all your contracts to make sure all the different responsibilities are clearly spelled out so there's no misunderstandings.
Thank you. That's some great advice. Our next one is, with the COBRA initial notice, we include it in our new hire packet. Is there a responsibility on our end to give a copy or to inform the spouse? Most of our notices are electronic, and we struggle with how to get them to the dependents.
Well, if they're all living at the same address, there's no problem. Is when you have individuals that live at separate addresses, that's the issue. And it's become a real problem because of healthcare reform, because of adult children now can be covered. Mm-hmm. And generally, it's more often than not that these individuals are living at separate addresses. So again, you have to be very careful in that and making sure that you have the addresses when people sign up of all the different dependents. And many employers don't do that. Mm-hmm. And to make sure you have all the addresses of all individuals that are covered by the plan.
The next one, with respect to the COBRA election, we just covered this. They asked if they send it to the employee's address, do we not, because they don't have the separate addresses on the dependents, is that okay? And I think based on what you said, the answer, no.
You got to separate, because remember, under COBRA, each qualified beneficiary has a separate election, a separate election right under COBRA. And so if they're living at a different address, you have to be very careful, because there are penalties under COBRA for not providing notices, and you have to be very careful in that regard.
How would a small employer know that someone became eligible for Medicare under COBRA if someone just either doesn't pay the premium or asks to term without reason?
I think you basically have to ask when they're eligible for because what shuts off COBRA and what affects COBRA is not being eligible for COBRA, not being eligible for Medicare, but actually being enrolled. Mm-hmm. And this is going to be because one thing that's very important that people don't understand this, and the insurance companies know this, and I've had situations where brokers come to me and said, we have a problem with Medicare because of the fact now they didn't understand, the employer didn't understand that Medicare is not considered employer coverage. So basically the COBRA coverage is secondary to Medicare. So the insurance company gets very upset because they could pay secondary as opposed to primary if they knew that person was enrolled in Medicare. So you got to be real careful in that regard, especially the insurance companies will look at this pretty closely if somebody has large claims. And the average individual doesn't understand the difference between COBRA coverage and regular employer coverage. So this is something to really look at.
And we actually have sorry?
Yeah.
We actually have a resource out there for employers about how COBRA affects Medicare, not just for your employees or former employees, but also for their dependents. So if you have any questions, you can email marketing@benefitexpress.com if you'd like a link to that, and we'll email you back a copy of that resource.
And and I've done seminars on this, and it's extremely complicated. And as an employer, you have to understand the interface between the different coverages and COBRA and Medicare, because there are various rules, because depending on when that person became entitled to Medicare, it could extend, for example, the COBRA coverage for that person for 36 months. So there's a very interesting interplay between Medicare and COBRA. Any other questions?
I don't see any typed, but we do have a hand raised, so I'm going to unmute Barbara right now. Barbara, you're unmuted.
Hello?
Oh, she put her hand down. I wonder if it's another person who realized that they don't have a microphone. If you do have a question, you can type it below if you realize that you don't have a microphone. But as of right now, I don't see anything typed. All right, I think we're good to move on.
Ah, thank you. You muted me, so I was ready to type something.
There we go. All right. I think we're
okay. No problem. Next, recommended. These are only different notices that are mandated only if you meet specific events. For example, wellness programs. That's the first one. Wellness programs are becoming real popular, and what's interesting about them, there's various notice requirements if you do have a wellness program. The first one is tells individual employees they can satisfy an alternative standard if they are medically unable to meet their wellness programs. And this is the more complicated requirement under the wellness program, because basically you don't have to tell them what the alternative standard is. You just have to tell them the fact that one exists. And you have an exercise program, and if you meet certain standards, you've walked so many miles a day, and there could be various different exercise programs. So basically what you have to do is if somebody isn't physically able because of a condition to meet these physical requirements, you have to tell them, come in and we'll give you something else to do. Same thing with smokers. If somebody can't quit, they're severely addicted, you can give them an alternative standard, but you have to tell them these alternative standards do exist, come in, we'll work with you. So applicable to wellness programs with a reward or penalty that affects the employee's cost of coverage under a group health plan, and that requires achievement of performance standards. So again, only if you have outcomes-based wellness programs that you have to meet this requirement. So this has to be given out to the plan participants, has to be sent out to all plan participants, and generally it's in a it's done annually in an open enrollment. And generally prior to offering a wellness program, you have to notify the employees of these requirements. Also, the EOC has new notice requirements. This is beginning in 2017, and with this new EOC requirement, it tells individuals what information will be collected and how it will be collected, and who will receive it and how it will be kept confidential. So the EOC is very, very make sure that information is protected. So you have to tell them, okay, we're going to receive information, like for example, blood tests. We're not going to see the blood test. It's going to go to the wellness provider, and they're going to, again, use the information to determine your eligibility for points. It's applicable to wellness programs that collect employee health information. And generally, and most wellness programs do this, they have a health risk assessments. And what most employers do, they have a third-party collected information. This has to be distributed by the first day of the 2017 plan year, so again, it's coming up very soon. Thereafter, the employers must receive annually before providing any health information and with enough time to decide whether to participate in the program. So this has to be given out with open enrollment material but only if you're offering a wellness program. Another requirement is a summary annual report. A summary annual report is only required if you have to file a 5500. So it's applicable to large plans, 100 or more, or if you're less than that, you have to file a 5500 because you're funded. And what this does, it summarizes the information on the 5500. So it just summarizes the information you file with the IRS. It has to be prepared by the plan administrator, sent to all plan participants, and it's got to be given out within 60 days after the Form 5500 is filed. Now, the 5500 is due at the end of the 7th month after the plan the plan year ends. So it's given out 9 months after your plan year ends. So annually within 60 days, which is 9 months, which I just indicated. Another form is a 1095-C, which has to be given out fairly soon. Tells and individuals of the health coverage they were offered by their employer or not offered coverage. It's only applicable to large employers who have at least 50 or more full-time or full-time employees. It basically tells them what coverage was offered, when it was offered, and whether that coverage was affordable or not. The employer has to provide it sent to employees who are full-time employees for at least a month. Very important. So if somebody works with you for a few weeks and leaves, never were eligible for coverage, and that full-time requirement only applies if you work 130 hours in any month. So if you are an employer that has a lot of turnover, you have to decide when you have to give that. Has to be given out annually by July 31st, but this year they created a special rule again. It doesn't have to be given out till March 2nd, 2017. So again, this is another annual requirement. It doesn't apply to all plans. It applies to only employers that are determined to be an applicable large employer. An applicable large employer are those employers with 50 or more full-time or full-time equivalents measured in the previous calendar year. Other mandated participant notices plans with specific criteria. Patient protection provider choice disclosure. Here tells employers they can designate a pediatrician as a primary care provider that requires no referrals and that is required to see an OBGYN. It's applicable to non-grandfather plans with PCP selection requirement or network provider and facilities provided by the carrier, or plans can send it and given to all plan participants. I don't think that many plans are subject to this requirement. And it must be provided annually with the carrier certificate of coverage upon open enrollment, or whenever the plan sponsor provides an SPD that has to be in it. Another is HIPAA high-tech breach notice. There's two breach notices. One of the breach involved 500 or more individuals. In that situation, notified affected employees and HHS that there was a breach of protected health information during the prior 60 days. Plans that have a breach during the past 60 days. That plan sponsor must send it. You must provide a notice to affected plan participants directly and to the HHS website. So you have to notify HHS of they had a breach. And many times would this happen, it happens, for example, when there's a break-in and the computer information is stolen, or there's a hack, or somebody gets their laptop stolen out of their car, and it includes all this information in it. So without reasonable delay, not more than 60 days after the discovery of breach, so it's extremely important if that happens. Now suppose the breach involves 500 or fewer individuals. Notifies affected individuals and HHS, applicable to plans that had a breach of PHI during the past year, and during the past 60 days with notice to plan participants. It's got to be provided by the plan sponsor, and you must only provide notice to the affected participants directly or HHS website. And here, if it's less than 500, within 60 days after the end of the plan year, notice to affected employees without notice, but not more than 60 days after the discovery of the breach. So you have to notify your employees quickly, but HHS within 6 days after the end of the plan year. And then this notice does not apply to that many individuals. Only you have a plan that's not subject to healthcare reform, special rules, general notice of pre-existing conditions, explains the plan's pre-X provision and how the prior credible coverage can reduce it, applicable to small employers that are allowed to renew on a non-health reform compliant basis. Most plans will no longer provide this notice because they no longer have a pre-existing condition exclusion. Very few plans, these are small employer plans, provide this notice, do it at initial enrollment and open enrollment. Also, it's in the SPD. And then another notice is a grandfather notice. If your plan is grandfathered under healthcare reform, to maintain grandfather status, a plan or coverage must provide in any plan materials a statement that the plan or coverage is believed to be grandfathered, and contact information for questions or comments. It is applicable to plans claiming grandfather status. It's got to be provided to by the plan administrator and provided by all plan participants. The disclosure requirement applies to any SPD, SMM, or benefit enrollment material provided to participants after 2010. And the agencies have clarified that it's not necessary for grandfather plans to provide a disclosure statement regarding the grandfather every time it sends out information, but you have to do it at least once, and also to any new employees. All right, does anybody have any questions? I know we covered a lot of material. If anybody wants that HRA SPC appendix, let me know. Send it to my email address, and I'll send you a copy. So I have that available.
I don't see.
Amanda, do you have any questions?
I don't see any typed questions, but if you do have a question you'd like to ask out loud, or if you'd like to type it below, you can just click the raise hand option and I can unmute you. But I don't see anything right now.
Again, as you can see, there's a myriad of different notices you have to give out. Please make sure you look at this listing very carefully. This will be available. Amanda, when will they get the slides?
We will be emailing them out by the end of the day today.
Okay.
So maybe.
If you have any questions, let me know. But I mean, I provided this only because, as you can see, there's a myriad of forms that myriad of notices you have to give out. Some are annual, some are at initial enrollment, others are only if there's specified events. So please make sure that you go with this list and check and see if you're providing these notices, because over the past 2 or 3 years, both the DOL and IRS have done audits in this area and are checking to see if you're giving out these notices. So please be very careful. Anything else, Amanda?
I don't have anything on my end. Let me just check the questions one more time.
Mm-hmm.
Oh, we do have one more, which is, oh, it just says the business associates notice. I'm not really sure what that means. So I think we're all set.
And again, the business associate is an agreement, not a notice. So, and again, the notice of privacy is you have to give to the employees. Okay, thank you, everybody. Appreciate it, and we'll see you on January 10th.
Yeah, we'll see you January 10th at 10 for constructing HRAs. Talk to you all soon. Bye.
All right, take care. Bye-bye.